Will work-life balance become a legal right?
Every employee to disconnect from work-related telephone calls and emails beyond working hours.
Will India get to finally protect its workers? And what is the truth about this right to disconnect bill? It's 9 p.m., you are having dinner and you receive another work email. What if you could legally say no to that work email? And this is exactly what the right to disconnect bill of 2025 is proposing. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to understand this right to disconnect bill of 2025 which has been proposed in our parliament. So let us begin with understanding that what kind of bill has been proposed. So this particular bill is a private member bill. That means this bill has been brought in our parliament by a person other than a minister. So any member of parliament other than minister who brings a bill, that particular bill is known as a private member's bill, and this bill has been brought in by Supriya Sule. So whenever we are talking about private members bill, it usually highlights the views, concerns, issues in the society, and in such a scenario, because it is not being brought by a minister, the probability of such a bill to be passed is limited, but in terms of policy making, it holds really good value. In this very context, the whole idea of this particular bill is to legally protect employees, especially from after works communication, and this is to bring in the idea of work-life balance, and also to ensure that with work there is insurance of mental health, there is insurance of dignity, and also proper rest. So this is the main purpose of the bill. Now let us move and understand that why do we need a bill that restricts after work communication or after work that we get to do. So when we talk about the given economy that we are living in, that is absolutely digital, where there is a possibility of 24/7 connectivity, and that connectivity is not limited in personal foray, it spills over into the professional foray as well, and that is why the lines between the personal and professional, the home and office, that have become blurred. There are continuous connectivity even after work through phone calls, through messages, through emails, and this leads to expansion of work hours where it is not at all seen as overtime. That means you do not get compensated for it at all. And because of this, we are getting to see excessive burnout, digital fatigue, decision fatigue, anxiety, mental health decline, and also overwork related deaths in some scenario. Example here would be the Pune EY case that we saw in this very year. It might have been forgotten, but we need to remember the cause so that in future we do not see such deaths because of these causes. And this is where this bill comes in to protect the line that is blurring, especially between personal, professional, work, home, and causing us these many problems. So now when we talk about the bill, the right to disconnect bill, this is not something unique that is being proposed. It has been in the global trend. France, Portugal, Australia, they have similar laws, and this is the bill which will revive the debate that we really need to bring in ethical labor practices, focus on mental health and the rights associated with, and also humane workplaces where humans are not working just as machines, they are considered and they are given rights of the humans that they deserve to live with dignity and have rest also. As I said, when we are talking about right to disconnect, let us understand that what are the key provisions that this bill is coming with. So the first key provision here is the core right that employees have. That is the main thing it is focusing on, that the employees are not obligated at all to respond to calls, emails, messages after designated work hours or during weekends or holidays. That means if you have clocked out of your work, if this bill becomes a law, then you would not be obligated to reply back, to answer an email, no matter how urgent it is, and that will be legally backed. The second key provision here is about the penalty which will be put on employers. So we are not just talking about right, we are making sure that how that right can be enforced. So the employers who will be violating this right, they will have to pay the penalty, that is 1% of total remuneration that is paid to all employees. So let's just say if this particular right is violated, then if that particular employer pays salary of 10 people and let's just say it is 1 lakh rupees, then the 10 lakh rupees is the total amount, and in this scenario he would have to pay 1% of this total amount. Furthermore, there is a provision related to overtime protection as well. So if there is any work that is performed after the official hours, that has to be compensated with overtime wages, and that will be applicable at the standard wage rate. That means it also prevents, if the employee is deciding to work after work hours, that they will have the payment for that, remuneration for that, and there will be no cases of unpaid digital labor. And this is one phenomena which is exponentially growing, especially in corporates, which needs to be recognized with due diligence so that it can be addressed. There are few other key provisions in this such as mandatory policy. When we are talking about bringing in these bills, it also talks about the organization, they have to frame an internal right to disconnect policy where they have clear communication protocols about this. So it will bring in the internal changes in the organizations as well, and which will be starting with right to disconnect policy. Just like POSH policy is something that is internally framed and there is a clear communication protocol training that is associated with it, with the legal framework that exists across our country, something very similar is being proposed for right to disconnect as well. Now when we have understood the key provision, now let us also move ahead and understand that how it has been told that this will be done. These are the things that will be part of the bill, but how this will be executed, that needs to be also understood, that we will be understanding through institutional mechanism. So the first thing that will be in place would be the Employees Welfare Authority. So this will be a statutory authority, and this will be the authority that will ensure the compliance, monitor of the employer practices, which are the provisions of this bill. They will address employee grievances if there are any. They will also conduct inspections and audits, and after that publish annual reports on digital labor well-being, that how exactly is the output of the effort that has been taken. Other than that, there has been also this proposal about digital well-being initiatives. In this, we get to see counseling services so that digital healthy habits can be promoted among employers and employees. Then digital detox centers so that the workers actually have certain ways to reduce dependency on digital tools, and awareness programs on mental health, over-connectivity and work-life balance. The idea of these initiatives is to bring in awareness. So when we were talking about the first thing that was proposed, that is the statutory authority, it was about institutionalization. This is about awareness, because at both ends, at employers end and at employees end, the unpaid digital labor is something that needs to be understood, and then only it can be properly addressed. Now in this context, there is also institutional mechanism related to employer responsibility. So in this context, they have established employer responsibilities, that what are the things that employers need to do. They need to establish a proper internal committee so that the rules, communications, protocols can be laid out. They also have to set clear rules for urgent communication, because each and every communication after work hour cannot be urgent. So what will classify as urgent and what will not classify as urgent, that needs to be set before. And employers will also be responsible for providing psychological safety, not just physical safety, but psychological safety, and also the training that comes with it, especially on healthy digital use. But when we are talking about such a bill which can actually change how the work has been going on across our economy, it matters and it affects a huge amount of dimensions here. So let us try to understand the dimensions that it is going to affect, starting with the social dimension. So when we are talking about right to disconnect, This will easily ensure that there is not just rest, there is also family time and also personal autonomy. It will reduce the mental health effects that we are seeing. It will reduce burnout, it will improve mental well-being, and it will overall promote work-life balance, especially in urban India. And because of this, we will see better outcomes in terms of productivity, in terms of social well-being, in terms of cohesion, and much more. Now, this is not the only aspects that makes it the reason to bring in such a bill. There are other aspects such as the economic dimension, where when we are talking about well-rested workforce, it will not only enhance productivity but also help in innovation. It will reduce the attrition rate that we get to see in the companies and the job dissatisfaction which is high in our economy. Other than that, it will automatically control the hidden cost of overworking employees. So sometimes overworked employees might seem like saving the cost, but their reduced productivity, reduced innovation, the high attrition, that means them leaving the company very soon. These are the hidden costs which are associated, which cost way more than that we can actually see on the paper. So that's why it will have effect on this. Another factor in the social dimension only that it will affect is in terms of gender. Because if we talk about females, they face higher after hours expectations, and also they are responsible for managing the housework. When they get this right to disconnect, especially after work hours, it will reduce the double burden that they have been experiencing for so long, and it will be a great support to bring in and enhance labor force participation, especially for females. Other than that, it is directly relevant to our constitutional context, where Article 21 talks about right to dignity, privacy and mental well-being, and this right to disconnect sits right here. So this is not something that we are proposing, that is not part of our constitutional framework that has been set, be it Article 21, be it Article 42, that is DPSP, where we talk about humane working conditions, and Article 38-41, where we talk about social security and welfare of workers as well. So you can use all these dimensions to actually make a framework to understand that how this right to disconnect impacts so many dimensions and associated with so many dimensions. On this note, we will be looking at some global examples. For example, France, which was the first country to bring such a law which legislated right to disconnect. It made mandatory inclusion in corporate HR policies, and that is why we get to see improved employee satisfaction and clarity in terms of work hours. Now, this happened 8 years back in France in 2017. Portugal has such a law where it penalizes workers who contact workers after office hours. The focus is on protecting especially the remote working employees. Other than that, we also have countries such as Belgium, Spain and Australia, which in 2024 brought this legislation where workers can legally decline after hours emails as well as calls, and this has strengthened union negotiations, especially in the digital sectors. So the impact has been positive across the nations, and if India actually wants to reap the benefits of this particular bill, if it turns into a law, it is important that we come in flexible, sector specific, culturally suitable rules to make sure that this bill, when it becomes a law, is able to deliver. Now on this note, I will be leaving you with a practice question here. You can put down your answers in the comment section. From your end, I also want to know, what do you think are the challenges which will come in place once this bill becomes a law in terms of implementation and execution? You can give me pointers in that context, put that also in comment section. And the answer of the previous question that was asked in yesterday's video is A. Now that was all from my side. Thank you so much.